Good evening and welcome to the Licensing Committee of 4th of December. So we'll start with apologies.
Thank you, Chair. Apologies have been received from Councillor Tinsley.
Marvellous. Okay, and we'll move to the minutes, pages 3 to 5. Has anyone got any issues they want to raise for that? Right, well, I'll propose from the Chair that they're correct. So I've got a seconder, Councillor Harden, and a vote in favour. Yep. And against, an abstention. Yep. Cool. Declarations of interest, you should know what you're doing with that by now. Agreements between Part A and Part 1 and 2. No Part 2, so that's easy enough. No urgent matters brought forward by the Chair.
One thing I'd like to raise, just for information for councillors, if I may.
Yeah, go for it.
On the 22nd of October this year, we had a successful prosecution for an unlicensed dog breeder. The dog breeder pleaded guilty to 4 charges of breeding dogs without a licence at Barnstable Magistrates Court. She bred 4 litters of puppies in 2023. The admittance of guilt was taken into account and she was fined a total of £17,163, which included fines and costs. We first received a complaint from Trading Standards regarding suspected unlicensed breeding. That was in October 23. A second complaint was then received from a member of the public who had bought one of the puppies, and it had a condition which is called entropion, which is a painful eye condition that dogs can get, which can be difficult and expensive to remedy. So after investigations, we got sufficient evidence to prosecute. We did make a number of attempts to encourage the breeder to license, which she didn't do. So it ultimately ended up in court and we won the case. The puppies she was selling were for £950 each. So she made a significant profit over that year. So it was a good result for us to get a fine. And obviously sends out a message to other unlicensed breeders that we can take significant action if you're caught. That is the second prosecution we've done this year as well. We did do another one in July where we got a £16,000 fine. So it's a good result and a good message to send out to those who are breeding illegally.
Well, excellent.
How many litters have you got to have before you're going to be licensed? I mean, I think that's the grey area, and you know.
It is a bit of a grey. If you have 3 or more litters a year, you definitely need a licence. If you've got less than 3 litters, but you're what's classed as operating as a business, so that means you're selling puppies and your business income is over £1,000 per annum, then you also need a licence. But it's a bit of a grey area to distinguish, are you operating as a business? There is a test we do, which is if you're advertising on pets for homes and things like that, websites and things like that. And obviously the value of the puppies, if you're selling 1 litter for £950 a puppy, that could be a lot of money, which would soon bounce up. So yeah, it's generally, if it's over 3 litters, you definitely need a licence. Under 3, we've got to do what's called the business test, which will determine if it's operating as a business as such. If you're having puppies and you're giving away for free, you're not making a profit, then it wouldn't come under the licensing regime.
Okay, well, thank you. Councillor Dart?
Chris, can I therefore suggest that we actually really publicise that? Because there are people who have litters of puppies, not necessarily intentionally, and they would sell and potentially make more than £1,000 profit very easily, which would be classed as business. I really think we should promote that.
Yeah, we have publicised it on our website. The successful case has been published, and it was in the press as well.
I had seen that actually, but I wasn't aware that the criteria was quite so.
It is quite.
You don't have to do a lot, and you're there.
Yeah, there's not a lot before you reach that threshold. So yeah, we are publicising it as much as we can. And obviously, we've got these cases to provide evidence to people that it is serious and you need a licence.
I think there's a perception. Sorry, Chris, Chair, that that you prosecute if there are things wrong with the puppies, or if they're cruelly bred, or the way in which the dogs are kept is appalling.
Yeah.
But actually, you know, there's a basis there that actually I wouldn't have thought about had to be licensed.
And we do have a graduated approach to enforcement. There are people that we've gone to them and said, you need, and they've said, oh, I didn't realise I need a licence, and then they've applied for one, we've got them up to the standards, and we've issued a licence. So we do try and work with people as well. We don't go straight for the prosecution. It's only the ones that don't comply with our requests that we go for prosecution. So we try and publicise it as much as possible.
I was just going to add to that, Councillor Dar. With that particular case, it was that real reasons, because one, they were doing back-to-back breeding of a dog that had a genetic eye condition, so the puppies were having those eye conditions. And the other difficulty with that case was, I can't remember if it's the mum or dad had a bite history, and then they were promoting them as good with children, which obviously, so that, I think if someone had a one-off litter, we wouldn't be looking at prosecuting. It was those factors taking into account, and they were continually breeding, knowing that condition, painful eye condition, was in place as well. So,
Well, I think that's good news all round. I mean, yeah. We'll go to the pavement licence policy then. So I'm assuming this is going to Chris, yeah?
Yes, the Business and Planning Act 2020 brought in a number of temporary changes to assist businesses reopening after the COVID pandemic. One of those changes was the introduction of a streamlined process for issuing pavement licences. It transferred the responsibility of issuing those licences from county councils to district councils. It was initially intended to only last for 12 months, and it ran in tandem with the county system. Now, with the introduction of new legislation, the Levelling Up and Regeneration Act 2023, that has created a series of amendments to the Business and Planning Act, which are significant to the District Council because it's moved the regime over to us permanently. The legislative amendments, some respect of the duration of the licences, a new renewals process, changes to consultation periods, enforcement powers, and introduction of fees as well. There's no legal duty on the authority to have a licensing policy. However, it is widely regarded as best practice to have a policy in order to provide guidance and good practice to applicants, the authority and members of the public, so we can issue them in a fair and orderly manner. It's proposed to undertake an 8-week consultation period and report the responses back to this committee, and then we can formally adopt the policy. The draft policies included in Appendix A. The policy has been developed in conjunction with the other Devon authorities. We've worked together to try and get a consistent approach across Devon, as the previous licence regime was Devon County, so covered the whole of the region. We've tried to stick with a consistent approach across the region. So over to the committee. Basically, really, I'm just asking to approve the consultation to start with, and we'll bring things back at a later committee.
Okay, well, Councillor Hackett.
Straightforward, we've all had it circulated, and I'm happy to move that we adopt the
Rose, yeah. Oh, Councillor Wheatley's gone for seconding. All right, any? Oh, Councillor Lavelle, what would you? Yes, by all means.
We're just saying we're not discussing what's in there. We're just saying it's a good idea
we can,
that it goes out
discuss.
for people to discuss.
No, we can. More than happy to discuss it.
I mean,
consultation as well. But
sorry, it does seem quite complex and involved on both sides, and I did think it was a little bit harsh that if you apply and have it refused, you lose your money. If you see what I mean, of the application. But I don't know whether like, if I applied and I'd got it a bit wrong, or I hadn't, or by taking away 2 tables and chairs, I'd be compliant. I mean, I'd not intentionally push my luck or whatever the refusal was being. And you refused it because I'd asked for too many tables and chairs. Just seems a bit harsh to lose your money, unless I've misinterpreted it. you know, I just wondered if you could then, you know, if I got it wrong by pushing my luck with asking for too many tables and chairs, and it would be an okay application if it was, you know, if I had one less table and chairs, do I have to pay the fee again? You know what I mean? It just seemed a bit harsh.
Yeah, the fee is split into two parts. There's an application fee and a grant fee. The application fee is payable when you apply and is non-refundable, and the grant fee is payable once we issue the licence. The application fee is to cover our expenses to process the application, process the consultation, do a site visit, and do the necessary to get the consultation in process. As part of the consultation, we won't refuse it outright unless there's a good reason. As you mentioned, if they want 20 tables and chairs, but we'll accept 10 tables and chairs, we'll negotiate with them, and if we can get to an agreement, we would issue the licence. It's only in really extreme circumstances
that we... another application fee.
They wouldn't have to do another application. If we can
the
negotiate...
way I read it.
Yeah, if we can negotiate an agreement during the consultation period, there wouldn't be a need for an additional application fee.
As I say, I can see that it's really complicated, and there's like, you know, you've got to liaise with.
Yeah, there's lots of consultation, and there's if we refuse
there is a cost involved. If
we refused the licence and then they came back at a later date, we would then charge them another fee because in effect it would be a new application. But initially, the application fee is payable, and we would negotiate and try and issue the licence if at all possible. If that meant amendments, they wouldn't have to pay.
Are we sort of like predisposed to encourage it? Because I mean, where practical. I mean,
obviously it's got to be where it's practical, where it can meet the requirements of the legislation. One of the big issues is the space left on the pavement to allow disabled people suitable access. They can't be forced out into the road and things like that. So within reason, we will accept applications, but there are some circumstances where it may not be practicable to allow the space for them to do it.
Okay. No, I mean, it's just a nice thing to do, isn't it?
Yeah. Obviously, we'll encourage it, and and it helps. Obviously, if it can add more people to their business, it's going to help their income.
Yeah. I mean, I'll be honest. I did think that the space for the margin of error for disabled access and that is quite significant. And you look around most towns and you try and find a space that's got that and space for chairs. It narrows down the options quite significantly, but needs must, I suppose. Councillor Lynch?
Yeah, I just wanted to ask about furniture permitted on page 11. I just want to ask about, controversially, I know this will be, A-boards. You know what I mean with A-boards?
Oh, yeah.
Now, they can be put on the pavement, lots of places in town, and I've had quite a few complaints, especially from people who's partially sighted, because it's quite a problem for them. I just wondered whether that's covered.
That's not covered within the pavement licence policy. That's covered by Devon County Council. They authorise A-boards. The only things we cover is the pavement licences, which is like tables and chairs and things for food and drink. The Highways Act still exists for any other things that go on the highway, so A-boards are covered by Devon County Council. And they have got a policy. There is a link. Have we put the link in there is in the policy. I think it might be in our guidance notes, actually. We have got some guidance notes about A-boards that I haven't included in the policy. So that's something we could include in the policy, actually, for a bit more information to applicants, that A-boards aren't covered by this licensing regime.
Thank you.
Okay. Any more queries? No, we'll go to the vote. All in favour? Marvellous. Excellent. Let me just get back to the front of the agenda. I believe that's... Oh, forward plan. Nearly. Yeah. So we've got nothing for the next... Yep.
We've got the the payment licence, we'll have to come back to this committee. It's proposed to start the consultation as soon as possible. We won't be able to make the 15th of January, but I propose to bring it back on the 26th of February meeting. And it probably makes sense to move the taxi licence policy to the 26th as well. And if it's okay with members, unless anything urgent comes up, we'd cancel the 15th of January meeting and do both policies on the 26th of February.
Well, I'm happy with that. I assume most members are going to be happy with that. I know my work will be very happy about that too. So yeah, we'll keep that as what we're going to do. The plan is, so we'll get rid of the 15th of January and we'll put both onto the 26th of February. I think that's all we've got then. Has anyone else got anything for the forward plan? No. Well, that's the meeting closed then. 6:46.